Welcome to Board District 5's Tenant Rights Town Hall with Bet Tzedek. My name is Jackie Goldberg, and I'm very proud to represent Board District 5. I'm going to let translation do that first.
Traducción ahora. Buenas tardes a todos, bienvenidos al foro virtual del Distrito 5 de la Junta Directiva sobre los derechos de los inquilinos con Bet Tzedek. Les habló Jackie Goldberg, orgullosa representante del Distrito 5 de la Junta de Educación.
Due to COVID-19, many families are struggling to make ends meet and face difficulties paying the rent. That's why we thought it would be so important to partner with a law firm, Bet Tzedek, to put on this town hall. At the end of the 2018-19 school year, there were over 269,000 students experiencing homeless in California. That's enough children and teens to fill Dodger Stadium 5 times over. And there are probably even more homeless children now. There is no more important time for us to be talking about the protections that are currently available to keep families in their homes.
Debido al COVID-19, muchas familias están luchando para que el dinero les rinda y les es difícil pagar el alquiler. Por eso pensamos que sería importante trabajar en colaboración con la firma de abogados Bet Tzedek al organizar este foro virtual. Hacia finales del año escolar 2018-19 había más de 269,000 estudiantes viviendo sin hogar en California. Esta cantidad de niños y adolescentes es igual al cupo de 5 estadios Dodgers y quizás ahora son más. No hay momento más importante que este para hablar de las protecciones que actualmente están disponibles para mantener a las familias en sus hogares.
Before we begin, I would like to take care of a few housekeeping terms.
Antes de comenzar, quisiéramos repasar algunos puntos generales.
First of all, you can listen to this webinar in English or in Spanish. For Spanish, click the interpretation button at the bottom of your Zoom window and then select Spanish. We have our wonderful interpreters from the LAUSD translation unit translating everything that's being said. So again, if you're at a computer and want to listen to Spanish, click the interpretation button at the bottom of your Zoom window and then select Spanish.
Primeramente, pueden escuchar este webinario en inglés o en español. Para escuchar en español, hagan clic en el botón Interpretación en la parte baja de la ventana de Zoom y seleccionen Español. Nuestras geniales intérpretes de la unidad de traducción de LAUSD están traduciendo todo lo que estamos diciendo. Así que nuevamente, si están en sus computadoras y quieren escuchar en español, hagan clic en el botón Interpretación en la parte baja de sus ventanas y seleccionen Español.
If you have any trouble switching the language to Spanish using the interpretation button, you can also use your telephone to call into our Spanish audio line, which is already up and running. The number and access code for that are on the invitation to this event.
En caso de dificultades para cambiar al español con el botón de interpretación, pueden escuchar por teléfono llamando a nuestra línea de audio en español, ya que está activada en estos momentos. El número y el código de acceso están en la invitación de este evento.
Second, we have American Sign Language interpreters as well. To continue to see them throughout the town hall, please make sure to keep your Zoom is set to gallery view so that you can see all of us at once. If you're viewing on a mobile device, just swipe left and you can see multiple panelists in your screen.
También tenemos intérpretes de lenguaje de señas americano. Para verlos continuamente a lo largo de este foro, por favor asegúrense de elegir vista de galería en Zoom para podernos ver a todos al mismo tiempo. En los dispositivos móviles deslicen hacia la izquierda hasta ver a varios panelistas en su pantalla.
Finally, you might notice that only our panelists are visible and can be heard or audible. As we go through our discussion, we invite you to ask questions by clicking the Q and A button at the bottom of your screen. We'll then get to as many questions as we can when we get to the question and answer session. Please keep your questions brief. You can write your questions in Spanish if you'd like. That's no problem. Also, don't worry about spelling or proper grammar. We'll get the point of the question. If you're joining us by phone, we will not be able to take your questions, but you can email any questions you have that aren't asked by others to bd5info@lausd.net, and we'll get back to you in the next few days. Now I want to welcome our panelists from Bet Tzedek, who we're so happy to have with us today. If you all wouldn't mind, perhaps could you introduce yourself to the audience and then begin your presentation. Thank you so much.
Hi, my name is Matthew Kay. I'm a staff attorney at Bet Tzedek in the Preventing and Ending Homelessness Project. My area is trying to prevent evictions from taking place, but if that's not possible, then going to court and trying to get a favorable outcome for clients.
Hi, everyone. My name is Isabel Jurado. I'm an attorney as well at Bet Tzedek Legal Services in the Preventing and Ending Homelessness Program.
Hi, everyone. My name is Yal Pineda. I also work at Bet Tzedek with the Preventing and Ending Homelessness Project.
Please go right ahead with your presentation.
Great, thank you. Looks good. First of all, I'd like to thank Jackie Goldberg and LAUSD for hosting this important event tonight. We're very happy to be here and trying to try to help explain the new rights that people have as a result of this new and confusing state law that people are talking about. And it is a confusing state law. But if you find yourself puzzled at all as we go along, rest assured that we will have contact information at the end of our presentation so that you can call us and we can give you a little bit more personal service. Now, I want to stress a couple things before we begin. Our presentation tonight reflects the law only as of today. We don't know what things might change in the next months or so. The legislature in Sacramento might very well decide to change the law, and we have no way of knowing what that might be. So it reflects the law only as of tonight. And secondly, we're going to be talking about the protections in the city of Los Angeles and the county of Los Angeles. If you live in West Hollywood, Beverly Hills, or Santa Monica, you should know that different laws are in place in those cities, and we're not going to be talking about those different jurisdictions tonight. We're going to be talking about residential evictions, so not commercial evictions. It's just because we have to limit, because of time constraints, we're limiting our remarks to tenants issues tonight. We're going to be giving legal information only. So telling you what the law is. If you have specific questions about your case and then specific facts, we'd ask you to hold those questions and maybe contact us with the numbers that you'll see at the end of our presentation. Now, you might notice that when we change the slides, there's going to be a pause. That's because there is simultaneous translation that's going on. And you should know that this is all normal and this is all part of the process tonight, because there is a simultaneous translation going on. And I guess I'll wait till the slide changes. So the agenda. you heard the introductions. Yael and Isabel and I were going to be talking about the tenant protections in place in LA City and LA County. We're going to be talking briefly about the unlawful detainer process. Unlawful detainer is just legalese for eviction. So what should you expect when and if this process happens to you, what rights you can rely on? We're going to give an overview of Los Angeles City and County renters' rights. And specifically, we're going to be talking about rent control. So we're going to, there are two different things sort of in place. There's the rent control, and these are the rights that you have pre-COVID they existed, during COVID they exist, and post-COVID when we get through this terrible ordeal we're all going through. These are the protections that apply, and they have nothing to do with the pandemic. Now, in addition to the rent control protections, we're going to be talking specifically about the COVID-19 eviction protections. You've heard about the new state law, AB 3088, and perhaps you've also heard about the federal law from the CDC. And these will take up probably most of the presentation tonight. So Bet Tzedek. Bet Tzedek started out in 1974. Basically, a group of lawyers and rabbis got together and they wanted to find a way to help Holocaust survivors. And from there, Bet Tzedek morphed into this sort of small, medium-sized firm that handles probably most civil issues, not all, but most. And we serve clients regardless of race, religion, ethnicity, immigrant status, or gender identity. And I introduced myself as belonging to, like Isabel and Yael, Preventing and Ending Homelessness Project. We provide eviction defense services for LA, Beverly Hills, Culver City, and West Hollywood. Again, we're going to be limiting our remarks to the city of Los Angeles and the county of Los Angeles. And that's important to know because different jurisdictions have different emergency laws in place. And it's important to know, first of all, where you live and what sort of protections those cities might have for you. And yes, we are definitely here to help you. There are several laws that will protect you as a tenant. It's well known that tenants who have lawyers are more than 70% likely to prevent being evicted. And of course, eviction at any time is a horrible thing to happen to you. But right now, it's more important than ever to keep people housed because of the coronavirus. It is also true that people who are homeless are likely to contract the virus. And so it is literally a matter of life and death right now. We want people to stay in their homes and to do everything we can to keep people in their homes. We will have our contact information at the end if you have any questions. And this is really an important point. These protections are time sensitive. You should not wait. Waiting leads to will lead to a bad outcome. I guarantee it. Do not wait until you are already in court. You need to take action as soon as you get a notice. And we're going to be talking about that right now. So this is basically an overview of the unlawful detainer process. It starts with a notice from the landlord, which is step number one. And the notice can be a 3-day notice, a 15-day notice, a 30-day notice, or a 60-day notice, or even a 120-day notice. But again, this starts the process. And let's say you get a 3-day notice to fix a lease violation or something like that. And let's say that in those 3-day notices, let's say the 3-day notice says, I don't know, stop playing the loud music at 3 a.m. or something like that. And let's say that you do nothing to fix that situation. The next thing that will come is the the summons and complaint. And this is sort of the formal beginning of the court process. So it's a summons and a complaint. And at that point, basically, you have only a limited amount of time to react, namely 5 days, not counting Saturday or Sunday or a judicial holiday. Now, let's look at the branch going off to the right. If you do not answer within that 5-day period, you essentially lose your proverbial day in court. Because if you do not answer, the landlord can get a default judgment against you and cut off any ability you would have to provide your defenses. You know, well, you say that I played my loud music, but in fact I didn't. That was my next door neighbor and not me, or something like that. So if you miss that window to respond, again, the landlord can come in and get a default judgment against you. And then at that point, they can apply to get a writ of possession, take it to the sheriff, and the sheriff will come out and lock you out eventually. And that is illustrated by the lower right-hand lock. And we want you to avoid that. So now let's say that you get the summons and complaint, and let's say you come to Bet Tzedek and we help you answer. There are two different outcomes once you answer. If you do come to an agreement with your landlord, you can settle. And basically settlement just means that both sides want to resolve this without having a trial. So the two options are obviously staying or moving out. And I should say that most of the time, the cases do settle. And but again, you need to answer. Once you get the summons and complaint, you do need to take action immediately. Now, let's say that the plaintiff and defendant, landlord and tenant, cannot come to some sort of a resolution of the problem. Then there will be a trial, and these trials are set very, very quickly. You should know that everything in the eviction world moves extremely quickly. So there will be a trial, either a bench trial, which the judge will decide, or a jury trial. Now, if the tenant wins, then that's great. But essentially, the only thing the tenant wins in an unlawful detainer action is the right to continue staying in the unit. You win. You basically win the ability to keep paying rent and pay back any back rent that you might owe. Now, if you lose, however, then the landlord will get possession, and again, it will lead to a lockout. So those are basically all of the possible outcomes that thank you, that's fine. We can go to the next slide. So I mentioned the summons and complaint, essentially the formal beginning of the court process. Now the first step in the court process of the eviction process, again, is getting that 3-day notice or a 15-day notice from the landlord. I should add, though, that if you get a 15-day notice to pay rent and you don't act on it, that doesn't mean you have to leave the apartment. In fact, we advise you not to leave the apartment, because you still have some options. You don't have to leave. Many tenants are just terrified when they get these letters. They don't know what to do. We would advise you, of course, first of all, to come to Bet Tzedek or go to another legal services provider, and quickly. Again, don't sleep on your rights. These rights that you enjoy as a tenant, they depend on your taking action and quickly. And don't wait. Don't wait because of whatever. It is a scary process, but you should know that there are many legal aid organizations in LA County that are here to help you. And certainly Bet Tzedek is foremost among them. This is a copy of the summons. The summons is essentially the court's document telling you, okay, you've been sued and you have 5 days now to respond. And again, those 5 days do not include Saturday or Sunday or judicial holidays. If you see this in papers that you get from someone who knocks on your front door, you should know that this is your key. You need to take action immediately. For a long time, recently, the courts were not issuing summons unless there was a health and safety reason for doing that. And this was because of an emergency rule that was in place because of the pandemic. But now we are seeing the summons issued, and this is a really important document. Again, if you get a document that says summons, it means you need to act, and act very, very quickly. So now, just a little bit about the important tenant protections that are already in place that have really nothing at all to do with COVID. Again, I mentioned this in the beginning. This is rent control, and these laws existed before COVID. They're in effect now, and they will be in effect to protect you after COVID. And you should know that in the city of Los Angeles, in the county, you have some really strong protections. Rent control. So rent control breaks down into essentially two different types of protections. One is rent control, and you see that under, let's look at City of Los Angeles 1, rent control. And for rent control, you can also understand that as rent cap. It limits the amount that they can raise the rent, they being a landlord, for most pre-October 1st, 1978 units. So for buildings that were built, before 1978, with 2 or more dwelling units in the city of Los Angeles, that's the rent cap portion, all right? And there are also just cause eviction protections. And the two are different. So there's the rent cap, and then there are the eviction protections. And just cause just means that landlords need a really good reason to evict you from most units. Now, the two go together. Let's say that there's a kindly old grandma who's been living for 30 years in a rent-controlled unit. She pays $1,000 in rent. Why so little? Well, she's been living there a long time, and in LA you have a rent cap that limits rent increases to basically the inflation rate. So she pays, she's a great tenant. She pays the rent always on time. She's wonderful to her neighbors and stuff like that. And let's say that the landlord is eyeing that apartment and says, well, if I can get rid of her, then I can bring in someone else and triple the rent. Now, without the second type of protections, just cause, a landlord could do that. He could just end the tenancy of that kindly old grandma who's done nothing wrong. He could do that and then bring in someone else and triple the rent. So that's why you have these just cause eviction protections, because without them, the rent cap would be meaningless, because you just get rid of the person and then bring in someone else. So just cause, landlords have to have a good reason to evict you. And a good reason is, let's say the tenant fails to pay the rent. Let's say the tenant violates some provision of the lease by, I don't know, damaging the unit or committing a crime in the unit or something like that. So there are those just cause issues where the tenant is at fault. And then there are also a very, very few reasons why, if the tenant is completely blameless, a landlord can still regain possession. If the landlord wants to move into the unit himself or put an eligible relative in the unit, he can do that, all right? The Ellis Act allows landlords to take all the units off the rental market entirely. Again, they can do that. If the city requires, because of an order, that the building be vacated, again, that would be another reason why a tenant who is otherwise blameless could be evicted. Now, in those three latter scenarios I just outlined, tenants would get relocation. So landlords would have to pay them money in order to move them, all right? So that's the city of Los Angeles. The county of Los Angeles also has rent control in the unincorporated areas. So that for the county, the rent cap is it limits rent increases for most pre-February 1st, 1995 units. And again, there is just cause, requires a good reason to evict for all units. And again, the rent cap and just cause, they go together, because otherwise, you know, a landlord could get rid of any tenant they wanted, bring in someone else, and then raise the rent. But this way, the kindly old grandma gets to live in that unit year after year after year, as long as she remains the ideal tenant that she is already. So now we're going to be moving from these protections that you have just by virtue of the fact that you live in Los Angeles or in the county that predated the COVID-19 pandemic. And there are different layers of laws, as you see. There's state law, and the state law, the new state law that everyone's talking about, it applies to non-payment evictions that my colleagues will be talking about in just one second. And the law is difficult. I mentioned this at the outset. If in the following slides you're having trouble following or you're not getting all the details, again, don't worry about it. People who've gone to law school are scratching their heads about some of this because it is pretty dense. And the fact that you have state laws, you have municipal laws and county laws, and these are illustrated in the beginning. I mean, I'm sorry, in this middle column right here. And these protect against non-payment evictions and other types of evictions as well. So you have state, municipal, and county. And then just to make things even more complex and difficult, you have this federal CDC order that also provides another layer of protections for people. And the interplay of all three is interesting, but it's also pretty difficult to understand. And that's why, again, we will put up at the end of our presentation our contact information. Don't despair, just call us, and don't worry about not understanding everything. So let's say you cannot pay because of COVID-19. Let's say you live in the city of Los Angeles. Now, you might know, if you've seen a webinar, that LA, because of the eviction moratorium, it doesn't require people to notify their landlord or even provide documentation. We at Bet Tzedek recommend that people do that just because it might get the landlord off your back. If the landlord is saying, hey, where's the rent? Where's the rent? Also, if you go to court later, it might be useful to have a paper trail established. But so let's say now, adding the additional layer of the state law, let's say you can't pay because of COVID-19, and you did notify your landlord that you can't pay the rent, and that is a good thing. The new state law, and we're talking about AB 3088, just to make it explicit, it requires additional steps to make sure you won't be evicted. So March 2020 through August 2020 rent. For the purpose of the state law, this is called the protected period. For rent that's owed between March 2020 and August 2020, landlord is supposed to give you a blank declaration for you to fill out, a declaration of COVID-19 related financial distress. If you fill it out and return it to the landlord, then your landlord can never, ever, ever evict you for that back rent. Again, if you fill out that declaration under penalty of perjury of COVID-19 related financial distress, and we're going to talk about what that would look like in practical terms. But if you fill that out and timely return it, then your landlord can never evict you for this rent. And it can never be the basis of an eviction lawsuit. Doesn't mean that the landlord can never get that rent, but the landlord has to go get it in a different forum, namely small claims court. And it doesn't mean that that rent is forgiven or canceled. You do still owe that rent, but that rent can never be used to make you homeless. Because that's what happens in a normal non-payment eviction. I'm not talking about in COVID, but before COVID hit. If the landlord won a judgment against you for non-payment, then the fact that you didn't pay a certain months of rent can make you homeless. But the new state law says we don't want to do that, and filling out that declaration will save you from being homeless, because again, can't be used as the basis of a UD. And this is just sort of a graphic illustration about how that works. Now, I talked about March through 20. It's called the protected period. Let's say you get a 15-day notice. And this is a change from normal, the normal notice that you would receive from a landlord under state law. It used to be only 3 days, but now you have 15 days to basically respond. And that 15-day period does not include Saturday or Sunday or judicial holidays. Now, you get that 15-day notice, the landlord comes and he gives that to you. I should also say, when we talk about getting notice from the landlord, be it a 3-day notice or a 15-day notice, it has to be in writing. It can't be a text. It can't be a voicemail. Your landlord, if she's passing you in the hall, she just can't say, hey, you have 3 days and you have to do this, or we're going to go to court. No, it has to be in writing. All right. Now, if you get that 15-day notice, here are some of the options. You can, of course, pay everything, and no problem. You get to stay, of course. But let's say you don't have that money, and again, we're talking about March through August, so that could be a sizable amount of money, right, at this point. If you fill out the declaration of COVID-related financial distress and return it to your landlord, you get to stay, okay? The fact that you owe that money, again, that money can never be used against you to evict you. You get to stay. And you are swearing under penalty of perjury that you've been financially affected by COVID, and we're going to talk about that in just a second. So option number 3, one is to pay everything, no problem. The second is take advantage of the new state law. 3, of course, you can always move out, and we don't recommend it. We don't recommend it because basically you're subjecting yourself to the pandemic, actually, and the uncertainty that surrounds it. You lose your home too. So your first reaction might be fear, right? But again, take advantage of number 2, the declaration of COVID-related financial distress. Turn that in. The landlord cannot go after you to try to evict you for that money. And number 4, which we also don't recommend, is do nothing. And if you just do nothing, as you can imagine, then you can be evicted. All right. So those are the 4 scenarios. Obviously, 1 and 2 are better than 3 and 4, because we don't want to see anyone become unhoused during this terrible time, this terrible uncertain time where you yourself are likely to, contribute to the problem of COVID. I think at this point, I'm going to be turning over the slides to a colleague.
Thank you, Matt. So now let's talk about the period of time from September 2020 to January 2021. If you can't pay your rent for these months, you can give your landlord a signed declaration of COVID financial related distress, and we'll be going over that declaration in a little bit. And you must pay 25% of the rent for each of these months by January 31, 2020, basically by the end of the month of January 2021. Not 2020, 2021, sorry. If you do both of these steps, you can never be evicted for the remaining 75% of the rent. You should also know that you can pay 25% of the rent however you want in installments each month. For instance, you can pay 25% for September at the time that you sign and submit the declaration to the landlord, 25% of the rent for October at the time that you sign and submit the declaration for the landlord, or you can submit the declarations and the money at the end of the month for January 31, 2021. Here you can see what the process looks like when a landlord tries to evict a tenant for the rent that is due between September 2020 and January 2021. First, the landlord needs to serve a 15-day notice to pay rent or quit. This follows the same process that Matt previously mentioned. As a tenant, you have a few different options. Again, if you can pay the rent, you should definitely stay. If you can't pay the rent because of COVID, you can deliver a declaration of COVID-related financial distress and pay 25% of the rent for those 5 months by the end of January 31, 2021. If you do both of these steps, you'll get to stay. The landlord can never evict you for not paying the remaining 75% of these months' rent. Again, if you do nothing, the landlord can file a case in eviction court. You should get legal assistance right away if you get a 15-day notice so that you can discuss your options. And like Matt mentioned, we do not recommend that folks move out because this does lead you to losing your home. This is an example of a 15-day notice to pay rent or quit that you may receive from your landlord. As we explained before, a written notice is the first step in the eviction process, and a 15-day notice is a type of eviction notice. Like Matt mentioned, your landlord simply cannot tell you you have 15 days to move out, or once you receive this notice, it doesn't mean that you have 15 days to move out because you may have options. So the 15-day time period refers to court days and doesn't include weekends or judicial holidays like we've mentioned previously. This is what your notice would look like for unpaid rent that came due during the period of March to August 2020. It will say notice of non-payment of rent between March 1st, 2020 and August 31, 2020 at the top of the page. And then there are blank lines for your landlord to write exactly how much rent you owe for each month. And the notice should tell you that if you sign and deliver a declaration of COVID-related financial distress to your landlord, you cannot be evicted for not paying this rent. So this is an example of a 15-day notice to pay rent or quit for the period of September 1st, 2020 to January 31, 2021. You can see that at the top, it lists this time period, September through January. The notice should tell you that if you sign and deliver a declaration of COVID-related financial distress to your landlord and pay 25% of the rent due for the months of September through January, by the end of January 2021, you cannot be evicted for not paying the remainder of the rent. Your landlord may ask you to complete a new declaration for each month from September to January. And this is an example of the declaration of COVID-19 related financial distress. This is what it should look like. It asks you to declare that you're unable to pay your rent or other financial obligations under the lease in full because of one or more related reasons to COVID-19. You also have to declare that any government assistance you've received or that you've tried to solicit or sign up for doesn't make up for your loss of income and or other increased expenses that are also related to COVID-19. If your landlord negotiated your lease with you in Spanish, Chinese, Tagalog, Vietnamese, or Korean, or any other language, they must provide you a copy of the declaration in your language. So now let's talk specifically about what the declaration of COVID-19 related financial distress says. It asks you to declare that you can't pay rent for one or more of the following reasons related to COVID-19. This could be loss of income, increased expenses related to performing essential work, costs related to health impacts of COVID-19, childcare or family responsibilities that can include increased childcare now that schools are closed, or any other reasons. And only one of these reasons need to apply to yourself, not all of them. And you don't need to tell your landlord which reasons apply. For instance, if the restaurant you used to work at closed because of COVID-19 and now you don't have a job, that does count as a loss of income related to COVID-19. Another example is if you had to stop working because your kids were sent home from school after the pandemic started, that can also count as a loss of income due to COVID-19. If you're able to keep working, but now you have to pay more for childcare expenses, like I previously mentioned, that also counts as increased expenses. And remember that you'll have to sign this under oath, so it's important that the declaration is accurate. So when should a tenant give a declaration? If you receive a notice to pay rent or quit, you'll need to return a declaration of COVID-related financial distress to your landlord within that period of 15 days. We recommend that you contact one of our offices for legal assistance right away, and it's best to get help with this process. We'll be sharing our contact information at the end of the webinar. And also, if you haven't gotten a notice to pay rent or quit, it still may be helpful for you to provide your landlord with this declaration if you know you won't be able to pay the entire month's rent. Again, contact one of our offices for assistance with this process. What happens if you miss the 15-day notice? The 15-day deadline, sorry, not the notice, the deadline. The 15-day deadline is very important. We recommend that you do everything you can to meet it, but if you miss the deadline for a good reason, the court might give you another chance to provide the declaration. You should contact one of our offices to get legal advice right away if you receive a 15-day notice from your landlord, and you should contact us immediately if you get any court papers for an eviction case. Most tenants do not have to provide any sort of documentation that shows that they've been impacted by COVID-19, and they can just provide the declaration by itself. But the landlord can ask for proof if they have already some evidence that the tenant is of high income before COVID-19. For instance, if on your rental application you told the landlord you were making $150,000, then the landlord could ask for your proof of COVID-19 related financial impact. For instance, that can be a letter from your employer letting them know that you were laid off because of COVID-19. If a landlord asks for this information illegally, there could be consequences and they might have to pay for your attorney's fees. Again, get legal advice if your landlord gives you a declaration to sign. And now I'm gonna hand it off to my colleague, Isabel.
Hi, everyone. So the next question is, what happens to the rent? We mentioned earlier that if you follow these proceedings, meaning you sign the declarations and you pay 25% of the rent from September to January, you can't ever be evicted for the remaining rent. But it's important to remember you still owe the rent. The landlord can seek it from you in small claims court. This could happen as early as March 1st, 2021, although local protections might push this date later. If your landlord files a small claims case against you for the rent, you can countersue the landlord or argue that you actually owe less rent because the landlord failed to make necessary repairs. Now, what if you already told your landlord you can't pay the rent under the Los Angeles city or county laws? As we mentioned earlier, you've probably heard of these protections, and you may have already provided notice to your landlord that you couldn't pay your rent due to COVID. These protections are still in place right now, and the protections are ongoing. So we're glad you were able to find out about your rights. But to obtain these state protections where for certain months it can't be a basis for eviction, you should still give your landlord a declaration of COVID-19 related financial distress. And again, you have until January 31st, 2021 to pay 25% of the rent from September 1st, 2020 through January 31st, 2021 in order to prevent the eviction. Depending on where you live, your local laws may provide you a longer time to pay back your past due rent. And again, we recommend you seek legal assistance for more guidance on this. In the city and the county of Los Angeles, they add additional limitations to certain evictions during the pandemic. They limit certain evictions that don't relate to rent payments as long as they're related to COVID-19. So there are no evictions for unauthorized occupants or other people that are living with you that may not be named on your lease. No evictions for pets, and also nuisance if related to COVID-19. Now, there are additional protections where no evictions for an owner move-in, where your landlord wants to move in or their family member, or an Ellis Act eviction, where your landlord seeks to take your unit off the market, or other no-fault reasons, where you're not at fault for the reason for eviction. In LA County, though, there is an exception for no-fault evictions where it is necessary for health and safety reasons. So what do you do if your landlord does not comply with these rules? It's possible that your landlord might not follow all the laws we just discussed. If they don't, remember that you still have rights. If your landlord files an eviction case, even after you provided the declaration and partial payment of the rent, you may have a defense to an eviction lawsuit. In the city of LA, if their landlords violate the city laws regarding tenant protections by evicting or endeavoring to evict them, tenants may sue their landlord through what is called a private right of action. And per violation, they can receive up to $10,000 in damages. In addition to defense to an eviction lawsuit and the city's private right of action, your landlord may be subject to other penalties and fines. You should definitely get legal advice. Our number's on here. If you live in the city of LA, you can file a complaint with the Department of Housing and Community Investment Department. And if you live in Los Angeles County, you can also file a complaint or report your landlord to the Public Health Department. Now, finally, we're moving on to the CDC eviction protections. It's a nationwide law that can also help you. It temporarily stops certain evictions until January 1st, 2021. It requires a different declaration than the one we discussed earlier. You'll have to make statements about your inability to pay rent, your efforts to obtain assistance for rent or housing, and the risk that you'll be homeless if you are evicted. It doesn't require a connection to COVID, so you can use this declaration if you owe rent from before COVID, and if you can't pay for a reason other than COVID, or if you signed a move-out agreement but never moved out. Because other laws we talked about today are generally more protective, the law is generally a last resort. So Here are a few takeaways from the different laws we discussed today. California law. If you comply with all of the requirements, you can never be evicted for COVID-19 related rental debt from March 2020 through January 2021. In Los Angeles City and Los Angeles County, they prohibit certain evictions for reasons other than non-payment, and they can give you more time to pay your rent. Lastly, the CDC order may delay eviction if you owe rent from before COVID, or you're unable to pay for reasons unrelated to COVID, or already have a judgment of eviction. So aside from eviction protections, there are also limits on rent increases in the city and the county. If you live in the city of LA in a rent-controlled unit, there's currently a rent freeze until the local emergency period ends. And as I mentioned, we're currently in that emergency period and it's ongoing. No rent may be increased until 1 year after the local emergency period is over. Now, in the county of LA, if you live in a rent stabilized unit there, there currently is a rent freeze through November 30th of this year, and it's subject to renewal in November. Now, if you live in the area but you don't have a rent controlled unit, all units in California, there's a limit. Your landlord cannot increase the rent of more than 10% during this state of emergency, and this is effective until March 25th of next year. So that concludes our presentation. Bet Tzedek Legal Services, we host a rapid response clinic 5 days a week from 9 a.m. to 5 p.m. You can request an appointment by calling this phone number and leaving a message if you're unable to reach someone, or you can email us at housinghelp@bettzedek.org. So for those on the phone, housinghelp@bettzedek.org. And for other additional legal resources, we also, LA County has this website where you can also, which you can also visit for legal assistance, called www.stayhousedla.org. Thank you.
Very good. Thank you so very much. So I'm going to now tell you a little bit about what happens now. First of all, those of you who are looking in the Q&A box and aren't seeing anything and you're thinking, oh my God, where's my question? My staff has been taking them down on a separate sheet of paper and sending them to me, and I'll be asking them. So your question did not disappear. Okay, first question. Can my landlord evict me if I refuse to pay more than the 3% increase? In other words, if he asks me to pay or she asks me to pay 5%, I say, no, you can only do 3%. Can they still evict me if I don't pay the 5%?
So what jurisdiction would we be talking about, just generally?
I don't know. I'm going to assume it's Los Angeles because they said 3%, because LA's is a maximum of 3%.
So in Los Angeles, the rent increase is between 4 and 6%. It changed in 2018. Oh. And it depends on what utilities, whether the landlord pays for gas and electric. If the landlord pays for gas and electric, then 6% would be the cap. If he pays for none of those, then 4% would be the cap. But as we saw during the local emergency period, there are no rent increases that are possible. And
so if my landlord says you've got to pay this rent increase, otherwise I'm throwing you out, what do you do?
I would contact Bet Tzedek or LAFLA or NLS And they could contact HSID.
NLS is Neighborhood Legal Services.
Yes.
And you can find them by just Googling or Yahooing Neighborhood Legal Services, and they'll tell you where they are.
Yes.
What was the other one you said, Matthew?
So Bet Tzedek, LAFLA, Legal Aid Foundation of LA, Neighborhood Legal Services of Los Angeles, Public Counsel, Inner City Law Center. We're all doing the same thing, and basically it's to handle questions like this. So there are no rent increases that are possible right now.
Okay, so if you're getting a rent increase, you tell them no, and you call a lawyer. You call Bet Tzedek, you call Neighborhood Legal Services, you get someone to help you, right?
That's right. That's right.
Okay, second question. Well, what are the grounds for being evicted right now?
Well, so if let's say you commit some sort of a crime in your unit or something like that, that would probably be one. Let's say that you get a 15-day notice and you do nothing. So a 15-day notice to pay the rent in October or something like that. And instead of, instead of filling out the declaration, whether that's applicable or not, let's say you just do nothing, you can be evicted for that.
Okay, so it doesn't mean there's no way you can get evicted, but if you take these precautions and fill out these forms within the time period, 15 days, it's going to be very hard for them to evict you.
Absolutely. There are these sort of overlapping layers of protection that we've tried to show you tonight, starting with the state law, and then continuing with the the county and the city moratoria that are still in effect, and then ending with the CDC. And it's not saying that you cannot be evicted. It's saying, though, that if you act in a timely way and don't just ignore notices, you have a good chance of staying in your apartment.
We live in Los Angeles. Oh, go ahead. I'm sorry.
Again, if you're committing some sort of a crime or damaging your unit, then yes, the landlord could probably still evict you.
Okay.
And we want to urge tenants to, during this trying period, try to do try to be a good tenant.
We live in Los Angeles and our landlords are evicting us. They say we do not have to pay rent until they ask us to leave. They're going to demolish the house we're living in, but they don't want to help us. They're just saying not to vacate until we are told to vacate. We owe the rent for this month, but they don't want to negotiate with us. The house is illegal. Its structure is, but we've been paying rent there for almost 9 years. They did say if we found a new place, they'd try to help us. What should we do?
So I think rather than try to sort of unravel all the threads,
yes,
I would just say it would be better to call Bet Tzedek.
Okay.
Because again, those are some complex facts.
Yeah.
And
I would say the same thing. I think that if the question you ask is a very specific to you, my best advice to all of you is we're going to put that number up at the end again. Call
right,
them.
and there's also, and again, as I said at the beginning, we don't want to be giving out legal advice, which is legal advice is the law as applied to your facts. We don't want to do that just because it's not a forum where we want that sort of a liability. But legal information, general sorts of questions, please. But yeah.
Okay, do the landlords have to prove they're renting to a family member?
I saw it in the chat, and it's they technically do not have to prove by submitting a birth certificate or something, but there are penalties for landlords who who sort of violate that, but there's no sort of proof at the beginning.
Okay. Do the landlords have to prove, but what if they claim they're taking it off the rental market, but they end up renting it after I'm gone?
So in those cases, and again, it would depend on some facts, but the tenant would get a right to return. They can't do that, obviously. Say, hey, we're going to Ellis all of the units. So take all the units off the Ellis Act, and then, 3 weeks later, re-rent. They can't do that.
Many of my constituents live in the Southeast LA County cities of Bell, Huntington Park, Southgate, Maywood, Vernon, and Huntington Park, and Cudahy. Do they have laws that are like this? Or if they live in one of those cities, how do they find out what city laws are affecting them? Because the state laws will be the same and CDC will be the same, but they're not in unincorporated LA County, although some of them are, and they heard you. But what if they live in Southgate? What do they do to find out what protections they have?
So the way I understand it is that the county voted on September 1st to make the county protections, COVID protections, a baseline floor for the entire county. Okay. Which is good.
Yes, very good, very good, very good. So then if you live in those Southeast cities, you don't have to go look up something else. You're covered by the county, even though you do not live in the unincorporated part of LA County.
So yes, it is a little bit tricky the way the mechanism works with those county protections, but we and advocates sort of debate among themselves. But yes, we're saying that because the county said that those county moratorium protections are now a floor for the entire county. Yes, we would say that there are some protections. Again, I would encourage those people, though, if they're seeing trouble on the horizon, to get in touch with a legal service provider.
Okay. I don't see any other questions. So I'm going to ask you to put back on the screen that 4 panels that talked about, what they can and can't do it, so that people might want to take, as I did, a photograph of it or a screenshot, and then also how to reach you again.
Sure.
That's the one. So my advice to my constituents is if you're like me and you don't want to write all this down, just take your phone and take a picture of it or a screenshot of it, because this is kind of the summary of it, right? Same thing here.
So you want the takeaways, right?
Right. And then finally put back up how to reach you folks. By the way, on the panel on my left, Bet Tzedek is misspelled.
Oh.
See it down there? On housing help at Bet Tzedek, it's missing an E. And the one on the right in Spanish is correct. The one in English is wrong. Over here. No, over here.
Oh boy.
That's wrong. That one's
You're
wrong.
correct.
That one's wrong.
That's a little bit embarrassing, actually.
That one's wrong. So take a screenshot of this.
Sorry, folks.
That's all right. We really appreciate you doing this. Bet Tzedek, I believe, means like house of justice, right?
It does mean house of justice.
Yes, it does. And the nice thing about the Hebrew word tzaddik is that it's also the same word for wisdom as well as justice and for charity. So this is an organization that sees as its obligation to help you. And they don't charge you money for doing that. Is that right?
That is correct.
Okay, I want to make sure that they understand that. So if you call them up and they give you help, you're not going to get a bill. you're just going to get help. And so unless I see any other questions, we have others. Did I miss something? Let me quick look. No, I don't see any new ones. Let me just say thank you to all of you that have come on today, because this is time that they donate to tell us how we can keep you safe. I want you to know that I have worked with this organization for about 40 years, and I can testify that when they tell you they can help, they can help. Do not delay. That's where we lose housing, is people say, oh, I'm so afraid, it's terrible, I better hurry up and move out. No, please don't do that.
Right.
Right now, at least until January of next year, you do have a lot of rights, and we want you to take advantage of them.
Right.
So let me thank all of you, Matthew, and everybody else that was here, our interpreters, and everybody else, and my staff for putting this together with them, and Josh as our tech jockey, and my chief of staff, and all of my staff who work on these issues with you. But mostly I want to thank Bet Tzedek, first for just being who you are, and second for coming and helping us inform people about how you can, not me, I'm not a lawyer, you can help them not get illegally evicted during this terrible crisis.
Well, thank you. And for my colleagues and me, thank you for being such a great host. I really we like the way that you move things along and sort of facilitated everything here tonight. And it's been our pleasure to be here.
Very good. Well, I'm very happy they contacted us. We didn't contact them. I want you to know that. They reached out and said, we can do this if you need this help. So thank you again. And to all of you, please stay safe. Wear those masks. Because if you wear your mask and you social distance, guess what? We can reopen our schools. And that's what we're trying to do. We want to reopen our schools. So please stay safe and healthy, but also do those things that the scientists are telling us to do so that we can get our cases down in LA County and our schools, even if it's only hybrid, get our schools reopened. Thank you for joining us tonight. Be safe. Have a very, very good evening and good night.
Thank you. Good night, everyone.